Fire Away tackles burning questions and hot topics in Canadian employment law, human resources, and dispute resolution. Hosted by Rudner Law, Fire Away is your go-to source for legal insight on the world of work. So whether you are an employee or an employer, a lawyer or an HR pro, let's ignite the conversation and get into today's episode. Here's your host, employment lawyer, mediator, and founder of Rudner Law, Stuart Rudner.
Welcome to Rudner Law's 2025 Year in Review, which will also double as episode 95 of Fire Away, the holiday edition. For those of you who don't know me, my name is Stuart Rudner. I've been practicing employment law since 1999, and our firm, Rudner Law, practices exclusively in that area. We work with both employers and employees, so we can see things from both sides. I also spend part of my time working as a mediator and arbitrator, so I can see things from a third, neutral perspective. So employment law is a fundamental aspect of all of our lives, and the courts have recognized that for decades, and they've recognized the fact that employment laws are critical, and it is very important to recognize and protect the rights of workers. What is remarkable is that for the 26 years that I've been practicing law, I've said the same thing, and it never changes. No matter what year it is, I say you would think that by now, given how important employment laws are, that they would be well settled. And the reality is, still at the end of 2025, they are anything but. The legislation keeps changing. In Ontario, our current government loves the name Working for Workers Act, and we're now up to the 7th version of the Working for Workers Act, and I'm sure we'll see more in 2026. Similar across the country, we continue to see employment standards legislation, privacy laws, human rights laws, occupational health and safety laws. Everything continues to change and will continue to change. And of course, the case law keeps evolving and change in many cases dramatically. In fact, the legal framework that we have now is incredibly different than it was when I started in 1999, and frankly, different than it was 5 or 10 years ago. And it will continue to evolve. We know that our Court of Appeal is going to be hearing a very important case very early in 2026, which may change things substantially once again. A lot of the change that we see is driven by social change. So the whole issue of remote work, which we will be talking about today, was driven by a global pandemic. And we see things like changes in how, as a society, we treat harassment or bullying or accommodation, etc. They've changed dramatically. They will continue to change, and the laws are usually trying to catch up. So all these things impact the workplace, and they impact the laws of the workplace. Speaking of workplace, I am very lucky. I have a great one. I have an incredible team with me of lawyers and staff who help us to assist our clients. And today I am joined by all of the lawyers on our team who are going to provide you with an update and a bit of a look forward. So this session is going to be divided into three portions. First, we're going to look back at the top employment law stories of 2025. Then we're going to look into our crystal ball, talk about what you can expect in 2026, with the caveat that we can never fully predict what's going to happen next week, let alone next year. And lastly, some of you have actually submitted some questions over the last few weeks, so we'll get to a bit of a Q&A at the end. So first of all, before I introduce the first speaker, let me just welcome everyone. I'm doing this across my screen. So we've got David, we've got Nadia, we've got Brittany, we've got Geoffrey, and we've got Alex. Thank you guys all for agreeing to put on your festive outfits and backgrounds and join me for this. So we're going to kick this off with a discussion of a topic that has seen tremendous evolution over the last few decades, which has only accelerated in the last 5 years. We're talking about the judicial treatment of termination clauses. So throughout my career, the other thing I've been saying is that contracts are the single best way that employers can protect their interests. And the termination clause is probably the most important clause in that contract. So when courts are changing the way they approach termination clauses, everyone should be paying attention. As the saying goes, your termination clause may not be worth the paper it's printed on. So David Gellis is going to start things off and update us on judicial treatment of termination clauses. David, I'll turn it over to you.
Thank you, Stuart. So you alluded to my first update, which is that employment law is far from settled. So I'm going to start off with some Ontario decisions about the wording "at any time" in termination clauses and whether or not that is offside. So let me start off with a brief recap. So last year, the decision Dufo versus Township of Ignace came out. And in that decision, the Ontario Superior Court of Justice ruled that the wording "at any time" and "sole discretion" breached the Employment Standards Act because employers don't have absolute discretion to dismiss employees. So, for example, the court found that that kind of wording might allow the employer to dismiss an employee where it's prohibited, such as an act of reprisal or for an employee taking or being on a protected leave. Dufo was appealed, and the Court of Appeal did not address whether or not "at any time" was offside. So that left employment lawyers with a lot of questions, and it was a very controversial decision because the Employment Standards Act, or the ESA, does not prohibit terminations on the basis of timing. So the whole idea that "at any time" was offside was something that was met with a lot of skepticism. But as we went on to 2025, it looked like Dufo was good law, and having "at any time" in your termination clause was fatal. And this was affirmed early on this year in February by the decision Baker versus Van Dolder's Home Team Inc., where Dufo was followed, and the termination clause at issue was struck for having the notorious "at any time" language. So early on this year, it does seem like this is fatal language that should be avoided at all costs. Flash forward to the summer of 2025, and we get two decisions that create the unsettled and conflicting case law that we're dealing with. So we got the decision Lee versus Wayfair Canada Inc. and Jones versus Strides Toronto. And in those two decisions, the Superior Court ruled that the wording "at any time" on its own is not a breach of the ESA, but the wording "sole discretion" is. So these two decisions look like a common sense correction, since, as I mentioned, there's no absolute discretion to dismiss, and there's no prohibition on timing, but there is no absolute discretion. So it's looking like we're getting a good correction, but shortly after that, before employment lawyers can settle in and make any changes, we get a new decision, Chan versus NYX Capital Court. And in this decision, the court follows Dufo again and strikes a termination clause for having that "at any time" language. So now we're left with this situation where it's unclear if "at any time" language on its own is a breach of the ESA, and this is creating a lot of uncertainty. Luckily, the Lee and Baker decisions are being appealed, and they're being heard together on January 16, 2026, which I think you alluded to in your introduction, Stuart. So hopefully this will bring us some much needed clarification from the Ontario Court of Appeal with respect to "at any time" and whether or not that language on its own will invalidate a termination clause. So that's the big update, the first big update. But regardless of what the Court of Appeal decides, our advice, which we always stress to our employer clients, is you always want to avoid using extraneous language in your termination clauses, such as "at any time" or "sole discretion." So even if it turns out that it's not offside, it's a best practice to keep termination clauses concise to avoid providing any potential grounds for challenging the termination clause. So with that in mind, the second major update that I'd like to discuss is a termination clause that was upheld. So this is another decision that builds on a 2024 decision. So last year in Birch versus Data Stealth Inc., the court upheld an ESA minimum termination clause. And this year, the Court of Appeal upheld the trial decision and ruled that the termination clause was enforceable. So this basically has the effect of putting the Court of Appeal's seal of approval on the termination clause from data stealth. And so this decision is really important because it illustrates what an enforceable termination clause looks like, and shows what language to include to make the termination clause clear, unambiguous, and effectively contracting out of common law. So
I'll jump in for a second, David, just because your time is just about up. So I think you're kind of leading up to the key point here, which is if you can summarize what the court said would be acceptable.
Right. So the court was just very clear that the clause here, contracted out of common law, expressly stated that the ESA would apply and that the employee's entitlements on dismissal were limited to those statutory minimums. So because of that, there was no ambiguity and the clause was enforceable. So employers who want to have this kind of clause should mirror the language in the data stealth provisions.
Perfect. All right. Well, thank you, David. I know it's a lot to cover. I appreciate it, and I'm still loving your hat. I know our producer Mark is loving it as much as I am. So, a couple of things. One, the Baker decision. If you read it, it was written by the person I consider to be my mentor, now Justice John Sproat. And if you read that decision, he's all but begging the Court of Appeal to take another look at this whole issue. So I'm really glad that they will be in January, and hopefully we'll have a bit more clarity there. But data stealth is what we are advising our clients, as David, as you said, remove any extraneous language. And then the one good thing that's coming out of all this is that termination clauses, which used to fill a page, now fill a paragraph if they're done well. And the other thing to take out of this is you need to keep up to date, because I can't count how many times we have all talked with our clients or contacts who said, oh, I just updated my contracts a couple of years ago by an employment lawyer, so it should be fine. And as we've reported to you guys through our blogs and social media and Fire Away and everything else, there have been so many twists and turns that you need to make sure you're working with your employment lawyer and keeping them up to date. So let's shift over to topic number 2, which is going to be an update on the law regarding constructive dismissals, which is another issue that has been coming up more and more in recent years. A lot of people have been contacting us, not because they've been let go, they still have a job, but see a lot of their duties are being removed or changed. The reporting structure has changed. They feel essentially that they're being sidelined, and in many cases, they feel like the employer is just trying to force them to quit. So Nadia, I'll turn it over to you to bring us up to date on the law as it stands at the end of 2025.
Thank you, Stuart. So a constructive dismissal occurs when one party to the employment agreement, usually the employer, unilaterally makes a substantial change to a fundamental term of the employment agreement. I will be discussing some of the latest updates from this year. So the first case is La Chapelle and St. Laurent Automotive Group, Inc. And this case highlights that a change that constitutes constructive dismissal is highly fact-specific. A new pay schedule was introduced during the COVID pandemic, which would essentially pool employee sales. But this felt more like a punch to the employee in question, their wallet, because he was a veteran car salesman, and he was so good that the company lured him back, and he rejected the pay scheme, the new pay scheme, because he was a high producer in this case. And the court agreed with the plaintiff employee in this case, basically saying that his refusal to return to an inferior pay structure was not a failure to mitigate, but rather it was a justified rejection of constructive dismissal. And he was awarded 7-month notice period. And the notice period in this case, interestingly, was extended because he was found to have been induced to return to work with the defendant employer, as well because of the impact of the COVID pandemic on the job market. So those factors ended up extending the notice period. Now, in calculating an employee's total tenure with an employer, so whether to consider only the most recent period of employment or the combined total, courts will examine several factors. So that includes inducement to return to work, the length of the break in employment, negotiation of a new agreement upon return, and continuity of benefits as if no interruption had occurred. Now, on to the second case. So this is Kennedy and Kingston Area Taxi Licensing Commission. And this case is interesting because it shows that where there's a sudden shift from years of positive feedback on an employee's performance, and there's more of a pattern of micromanagement, belittlement, or undermining an employee's authority, that's going to strongly support the finding of constructive dismissal. And this case also shows that long service employees in specialized roles can periods. Now, there are a lot of important facts in this case, but what I want to point out is that in this case, the employer did hire an HR consultant to investigate the plaintiff's harassment complaints, and they concluded that no harassment had occurred, but included several recommendations such as supervisory or sensitivity training, creating a job description for the plaintiff, and appointing a mediator. But none of these recommendations were ever carried out or shared with the plaintiff. So this is a perfect example of what not to do as an employer. And on top of that, the employer tried to introduce a new employment contract that would restrict the employee's termination entitlements to only the minimums required by the employment standards legislation, and the employee had refused to sign it. And then when the employee took stress leave, the employer responded by taking his car, phone, computer, and posting his job. So in this case, the employee not only received a 24-month notice period, but also $25,000 in aggravated damages because the court found that the employer had acted in bad faith and created a hostile work environment. Another case, Taylor and Saladics Inc. This basically concluded that temporary layoff provisions are not termination provisions. So it's interesting in that regard. So where an employment contract contains a valid temporary layoff clause, the clause is not going to be rendered void if the termination provisions in the contract are found to be void. Now, another case that I want to talk about, it actually has a very interesting fact pattern. So this is Posel and Sharon Veterinary Clinic Professional Corporation.
I will jump in for a second, Nadia, just to give you a 30-second warning.
Okay, thank you. And what happened is a client's cat escaped, and there were threats against the clinic. And the clinic owner took reasonable security steps, but the plaintiff vet demanded that the owner send a formal termination letter to the client as a precondition for her return to work. And when the owner hesitated, the vet said that she wouldn't be coming back. The court found that the vet's demand was unreasonable and treated the refusal as a de facto resignation, which confirmed that an employer isn't legally required to meet an employee's unreasonable preconditions for returning to work. So it goes to show that courts will assess constructive dismissal through a lens of common sense and proportionality. And although an employer's request for the return of property may be seen as a constructive dismissal in many situations, that's not always going to be the case. So I just want to point out that we regularly help our employer clients ensure that they implement proper policies and procedures and clearly document changes to employment to minimize potential liability. And similarly, we regularly help our employee clients navigate the complexities of a constructive dismissal allegation or claim and ensure that they get what they're entitled to.
Right. Thanks, Nadia. Again, I know there's a lot, and one of the first points you made is probably the most important. I mean, courts will look at all these cases on a fact-specific basis, which is why you always hear us say it depends when we are asked if something is constructive dismissal. We don't hear about a lot of cases with cats escaping, though, so that was kind of interesting as well. All right, let's keep things moving along. So we're going to talk about mitigation, and what's interesting is, of course, we've talked a little bit about notice periods, and we're going to talk more about them, but it's always important to remember that when we're talking about the entitlement to notice of dismissal, the law of mitigation can be a critical factor in impacting someone's entitlement. So with that, I will turn it over to Jeff and all of the lights behind him. I can call you Mr. Griswold if you'd prefer.
That's it. I've got lights on both fronts here.
Nice. I love it. Well, I'll turn it over to you to talk about mitigation.
He worked really hard. Great washing machines. It's just remains the best line of any movie ever. Yeah. Thank you, Stuart. So, as Stuart's as mentioned, and as Nadia was discussing the last in her section just now, when an employee's employment is terminated, they're entitled to something called reasonable notice at common law. And we're going to discuss this more in greater detail, but this is subject, this is an assessment by the court of how long it's going to take the employee to find their next job. And this is based on their age, length of service, character of employment, and anything else the court deems relevant or material towards that assessment. The court can't actually measure how long it's going to take the employee to figure out. They can't measure what's important, so they take what they can measure and make it important, is what I always like to say. This is not intended as a windfall for the employee, however. This is intended as a bridge to the employee's next job. And I'm trying to get this metaphor to work, so just bear with me. But essentially, the employee has to take efforts towards crossing that bridge to get to their next job. And this is called the duty to mitigate. And the employee has to look for a similar position in terms of the employee's, the lost position in terms of their skill, status, location, and compensation. So they've got to try to find another job to replace the earnings and the status and the position that they lost from their previous employer or from the previous role. The Supreme Court has helped us out. In 2008, they ruled in Evans and Teamsters Union that the employer, to permit the employee to mitigate, can offer the employee their job back, and the employee effectively has to put this position back unless the circumstances of the employee's termination were humiliating and a reasonable person would not accept the return of the position, essentially. So unless the employee was dismissed under really bad circumstances or they were harassed or something like that, they've got to take that job back, and that's going to be a reasonable means by which they can mitigate their losses. One question that was kind of up in the air until recently is, when does this job need to be offered? And in May of this year, the Court of Appeal for Manitoba helped us and provided some clarity on this in Brown and General Electric Canada, or General Electric Canada Inc., rather. This is a situation where Mr. Brown was working for a company that he had founded himself. General Electric hired him and bought the company and signed him to a 5-year deal where he would have a retention bonus at the end of this 5-year period. About 2 years into this, General Electric sold off the division Mr. Brown was part of, and new position that he was going to, or the new place that had purchased the division, offered Mr. Brown a position. The position was identical to his one with General Electric. The only thing that was up in the air was the retention bonus, and it wasn't clear if the new company was going to pay this bonus or honor this. Negotiations were ongoing, and Mr. Brown decided these and advised General Electric and the purchaser that he had no intention of accepting this new position and that he would remain with General Electric, despite the fact that the division was going away and his job was going with it. So he came to the end of his employment. His employment was terminated, and he brought litigation against General Electric seeking entitlement to reasonable notice at common law. The court, initially at trial and then obviously in the appellate decision, reviewed the new position and found that this was a reasonable means by which he could have mitigated his losses. And by failing to accept this position, he had failed in the duty to mitigate and thereby negated his entitlement to reasonable notice at common law. The court ultimately only awarded him his retention bonus, which is about $150,000, and it did not award him his entitlement to reasonable notice, which he had claimed, which is about $760,000. The takeaway here is, one, that this is what happens when an employee turns down comparable employment, and it is possible to offer an employee a new job before their old job has gone away. So from an employer's perspective, we assist employers all the time with situations like this. From an employer's perspective, not only do we want to consider, after we've terminated the employee's employment, can we offer them their job back if they are contesting their notice period, but can we offer the employee another position within the organization at a time, even if we make it as a period of working notice? And if the employee turns it down, we now know potentially the impact this is going to have on their entitlement to reasonable notice at common law. So that's the first thing we want to talk about. That's the first case for mitigation for the year. The second one is Hill and Canyon Dental Center, which is a case out of Alberta. And this is in
Just
terms of,
so you know, you've got about a minute for the second case.
A minute left. Okay, I'll go really fast on this one. It's not a lot of stuff to talk about. This is an employee who was working one day a week for a dental practice. Their employment was terminated, and the duty to mitigate kicked in. The employee, in no other way to put it, just did not properly equip themselves in terms of observing the duty to mitigate. In the course of a year, they applied for 19 positions. The employer showed that there were approximately 150 positions they could have applied for, and ultimately called somebody as a witness who managed 3 dental practices in the vicinity of this employee's like home, and said that not only were all these positions open, but that this employee's availability was highly desirable, and also we offered this person a job and they turned the job down. The employer tried to countenance the employee's rejection of this job as failure to mitigate. The court didn't agree and said that there possibly were legitimate reasons for why the employee turned the job down, but that the employee had in fact failed to mitigate, and ultimately, as I reach my point, reduced the notice period by months. The thing that kind of stands out to me about this case is the employee was made $1,000 a month. The employer saved itself $2,000 and probably spent $50,000 in legal fees doing this. So the lesson, the takeaway for this is just because you can doesn't mean you should. And you always want to look at your legal spend versus the potential positive or negative outcome at every stage in the process.
That's a great way to end it. So thanks, Jeff. And yeah, a lot to cover again. And look, we always try to remind everyone that you guys are calling us with business questions and business decisions to make. So we might say, hey, you've got a great case, but to Jeff's point, do you want to spend $50,000 to save yourself 10? So you've got to factor that in. But also, another important way to take it of all that is, and this is more on the employee side, never act in haste or out of emotion. We have far too many people who have been let go. And if there is a possibility of going back, which doesn't exist often, but if there is, they'll say things like, oh, I'm never going back there. And I'm not. And as Jeff said, unless it would be humiliating or embarrassing or there was harassment or bullying, then you may well be expected to take that job back in order to mitigate your damages. So keep that in mind. And from an employer perspective, consider being strategic. And if you're told by your employment lawyer that you have substantial liability, think about whether you can offer the person their job back and mitigate that. So, all right, let's move on from the duty to mitigate to the duty to accommodate, which has had a lot of attention in the last couple of years. So Nadia is going to be back to talk about that. And it's been fascinating to see, under human rights legislation, the growing list of grounds that are protected, as well as the growing expectations regarding things like accommodation. And the worst thing you can do as an employer is just dismiss a request for accommodation out of hand without giving it proper consideration, getting proper legal advice, and documenting the fact that you considered it. Because and Nadia, I don't want to steal your thunder, but the duty to accommodate has both a substantive element, i.e. you're supposed to accommodate to the point of undue hardship, but also procedural. And that means that you need to have a proper process in place. So I'll stop talking now and turn it over to you, Nadia.
Thank you, Stuart, for sharing my thunder. So I'm going to discuss updates with respect to accommodation. Employers are obligated to accommodate employees' legitimate needs up to the point of undue hardship, which is a very high threshold. And accommodation is a two-way street with both employers and employees having rights and obligations. And the cases from this year definitely do highlight that. So the first thing that I want to point out is a decision called Carly and Waterloo District School Board. In this case, the employee alleged discrimination when her preferred AM shift was not granted. So they had requested a morning shift. The employer requested further medical information and an IME, which is an independent medical examination, and supported gradual return. They offered a PM shift with a plan in place. However, the employee rejected it and basically alleged that this breached the human rights legislation. Now, interestingly, the Human Rights Tribunal of Ontario, or the HRTO, they held that they didn't have jurisdiction to hear the complaint. But they commented that there's no entitlement to perfect accommodation, only what is reasonable. And they also pointed out that employers may request medical information and IMEs, and employees must cooperate. They can't insist only their preferred option is acceptable. So this case really shows that the accommodation has to be reasonable, but not the employee's preferred or ideal accommodation. The next case is Wissack and Sunnybrook Research Institute, which is a great example of a best practice case in terms of the employer's procedural and substantive duty to accommodate. So in this case, the employee alleged failure to accommodate return to work after a 14-month paid sick leave. And the tribunal found that the employer was engaged throughout the accommodation process, requested medical information, and funded an IME. The IME showed that the employee was fit to work, but not in their old role. And the employer offered 2 suitable alternate positions, which the employee declined. So the tribunal held that the employer satisfied both its procedural duty to accommodate by engaging and requesting medical updates and funding an IME, and also its substantive duty to accommodate by offering alternate suitable positions. So this goes to show that the accommodation process is really a two-way street, and the employee has to cooperate in the process. And if reasonable alternate roles are offered, that they should be considered. Now, another important trend in accommodation for this year is that there are shared responsibilities in accommodation. So in D. Arienzo and TTC, essentially the employee who was a maintenance supervisor with a fairly physical component to their work, there was a back injury, they were offered modified duties and took the position, was totally disabled. And at some point, the employer hired a private investigator and discovered that the employee was actually capable of doing a lot of things, and then terminated the employee's employment, which the tribunal upheld because the termination was based on dishonesty and failure to cooperate with the return to work plan, as opposed to relating to disability or request for accommodation. So it really reinforces the shared responsibility in the accommodation process, and that employees must engage meaningfully in the accommodation process. Now, as I mentioned, in terms of trends, there's a trend where there's a big focus on the process of accommodation. And as you'll see from the cases where it was held that the employer did fulfill their duty to accommodate, the employer fulfilled both the procedural duty and the substantive duty to accommodate. And the other trend is that the accommodation must be reasonable, not perfect, as well that IMEs are proper where the medical documentation is unclear and return to work plans relying on them are upheld. Now, as employment lawyers representing both employers and employees—
I'm going to give you the 30-second warning.
Thank you. So as employment lawyers representing both employers and employees, we've also seen an increase in requests for accommodation based on neurodiversity. And this often poses a unique challenge for employers as they're not as used to getting these requests, but the term disability is defined very broadly for the purposes of human rights protection. And such requests should be handled with as much care and consideration as other accommodation requests. We also help employee clients who have recently been diagnosed with ADHD and/or autism spectrum disorder navigate the complexities of the accommodation process.
All right, thanks, Nadia. And yeah, I think it would be interesting to see. Neurodiversity seems to be something I think we'll be seeing a lot more of in terms of accommodation over the next couple of years. But a couple of really important points to take out of that, and the biggest one is the employee's duty in the process to cooperate, and also the fact that the employee does not get to choose their preferred form of accommodation. And we see this all the time. Often doctors take it upon themselves, I think sometimes at the request of the individual, to say that they should be given X time off or whatever the case may be. It's not up to the doctor to decide either. You're entitled to know as an employer what the limits are and what needs to be accommodated, and then you can assess what's reasonable. And as long as it's reasonable, you've met your duty. So a lot more to unpack there, but we'll leave that for another time. I want to keep things moving, and we're going to shift gears a bit and talk about damages. And the reason this is so important is because we always talk about dealing with things like requests for accommodation or terminations, constructive dismissals, and we're always looking at, well, what's the potential liability? And so this is a big topic we divided into two. So first, well, Alex Minkin, who is now on the screen, is going to talk about both of them. But the first one is going to be talking about post-termination compensation for things like variable pay, like bonuses, equity, etc. And later on, we're going to talk about general damages. So Alex, I'll turn it over to you. I'm just admiring your background. Was that AI? Did you do that, or did you find
This
it
is
online?
AI generated. I didn't draw this myself.
I'm assuming you didn't draw, but I was wondering if you found it online or had it generated. So we'll have to compare prompts later on. But anyways, I will turn it over to you to talk about damages.
Sounds good. Thank you, Stuart. So David earlier discussed the issue of termination clauses and whether they're legally enforceable. If a termination clause is unenforceable, or if there is no termination clause, then the employee is entitled to reasonable notice of termination pursuant to common law. So I'm going to discuss a recent case that considers what compensation must be included during the common law notice period. The general rule is that damages in the common law notice period include all of the compensation that the employee would have received if they had continued to be actively employed during that period. So that would include base salary, that would include benefits and bonuses, but it would also even include equity-based compensation such as stock options or restricted share units that would have vested in that period. But this general rule can be displaced by a contract, so long as the contract is clear and unambiguous, and so long as that contract does not breach the employee's minimum statutory entitlements. There are a lot of court decisions that consider the enforceability of contracts that limit an employee's right to receive stock options or RSUs during the common law notice period. And just a few months ago, the court released the decision of Wigdor and Facebook in July of 2025, which was a very interesting court decision on this subject matter. So in that case, the employee was entitled to receive common law notice because the termination clause was found to be unenforceable. Now, if their employment had continued for the duration of the common law notice period, they would have been entitled to some very lucrative RSUs, restricted share units. However, the contract stated that all RSU entitlements are immediately forfeited as soon as the employer receives notice of termination. So the court had to consider whether that RSU provision was enforceable. And in its decision, the court found that the RSU provision was enforceable, which meant that the employee's RSU entitlements were forfeited. They weren't required to receive them, even though they would have vested during the common law notice period. One important issue that the court had to consider was whether that RSU provision in the contract violated the minimum statutory entitlements of the Employment Standards Act. And the court found that they did not, that this contractual provision did not violate those minimum statutory entitlements. Although the statute requires employers to maintain the employee's wages and other terms of employment during the statutory notice period, the court found that RSU entitlements are not wages for the purpose of the legislation. So there's no requirement to maintain those entitlements during the statutory notice period. And for that reason, the clause did not violate the statute. So this was a very important decision. It clarifies the law because there are not a lot of decisions on this specific point about whether stock options or RSUs are required to be extended during a statutory notice period. In this particular case, the finding was firmly in favor of the employer on that issue. However, the decision is under appeal, and we expect to receive further guidance on this issue from the Court of Appeal. So we'll be watching that appeal decision, which we expect to take place in 2026. Perhaps we can talk about it on next year's end of the year Fire Away show, and hopefully that will provide more clarity for us all on this area of the law.
Awesome. Thank you, Alex. That's and this is huge, right? And it gets back to the point I made at the beginning about how important, termination clauses are in contracts, because not only can you limit the timing or timeline in terms of how much notice you have or termination you have to give, but what's going to be included. And still the most common mistake we see in these clauses, it says where they say we'll continue salary only. And if you're talking about someone who's making 40, 50, 60% of their compensation through variable pay, then it may well be offside of the Employment Standards Act. And more importantly, if it is, you may be on the hook for their full compensation for the full common law notice period, which can be massive, as we've seen in a number of cases. So thanks for that update. And I know you'll be back in a few seconds to talk about damages, general damages. But first, we're going to go back to Nadia. Nadia, I don't know how we did this agenda that you seem to be doing every second topic, but we appreciate that. So now we're going to shift to talk about a topic that is, front and center for so many organizations, which is the return to the office. So we've seen, COVID hit, everyone scrambled to figure out how to work from home. And then it was no longer necessary, but a lot of organizations seem to like having many of their staff working from home. And then it became hybrid. And now it's still hybrid, but there is a very strong push to either more days in the office or completely back in the office, which has not gone over very well with many individuals. So this is an ongoing battle. And Nadia is going to give us the update on what we saw in 2025 on that front.
Thank you, Stuart. So this year, major Canadian banks like BMO and RBC have mandated a 4-day in-office return, which certainly raises legal questions for employers. And we've also seen a lot of other employers mandate return to the office. Some are phased transitions, some are, 5 days in the office or 4 days in the office. But this is a big change from our COVID days, obviously. So the first thing to keep in mind is that the contract is key. And this is sort of and probably the point that ties all of our sections together, because I think the contract does come up in each one. So employers can generally dictate the work location unless a prior agreement or past practice like prolonged remote work dictates otherwise. So if remote work became an implied term, a unilateral return to the office mandate risks constructive dismissal. Now, employees can legitimately refuse a return to the office based on constructive dismissal or a need for human rights accommodation. So, for example, if it's protected under the ground of disability or family status under the human rights legislation. So it has to be linked to that. It can't be a preference. Employers, as I said earlier, they must accommodate to the point of undue hardship, but again, the accommodation has to address a need as opposed to a preference. And the accommodation process also requires open dialogue. Now, when it comes to constructive dismissal and remote work, things can get fairly complicated. It's not always going to be the case that an employee can successfully allege constructive dismissal when their employer is mandating return to the office. But if there's been successful remote work and then there's a sudden mandatory return to the office, that can be seen as fundamentally altering the job terms that can lead to a constructive dismissal claims. But employers who documented remote work as temporary, they have more flexibility in this regard. So I just want to point to some of the best practices for return to the office. And first, communication. So state that the arrangements are temporary from the start. Make sure that this is set out in writing. Secondly, phase transitions. So implement gradual returns as opposed to a sudden mandate that there must be return to the office 4 days or 5 days a week. Engage in dialogue. So that's the third point. Make sure that you're addressing employee concerns proactively. And finally, you want to consider accommodation and be prepared to address the legitimate accommodation needs. So a nuanced approach and making sure that you seek legal advice from an employment lawyer, those are essential for a smooth and compliant return to the office. And as we keep saying, documentation is critical in this regard. We regularly help our employer clients ensure a smooth return to the office, and making sure that the transitions are smooth, ensuring that there's proactive advice and implementation of strong contracts and policies. And as for employees, there may be a legitimate need for accommodation, or you may have a claim for constructive dismissal. We regularly help our employee clients ensure that they get what they're entitled to when it comes to these situations.
Awesome. Thanks, Nadia. And yeah, it'd be interesting to see how this plays out early in the new year, because we've seen a lot of organizations that have made bold announcements about return to the office and then had to scale that back when they had a lot of pushback. And I believe you're going to be coming back in the next session to talk about return to the office mandates in 2026, right?
Yes, yeah.
Perfect. Okay, so we'll cover that later. So next, we're going to keep moving forward. We're going to talk about changes to employment legislation in 2025. And Brittany Taylor is going to be covering that with her wrapping paper background. I'm just waiting for her to, there we go. Brittany Taylor is a partner in the firm and obviously enjoying one of the perks of partnership, which is that before you even do your first session, we have some associates doing 3, apparently.
It's amazing. This is what it's all about. I've worked hard for this.
You can put your feet up on the desk and relax. So I will turn it over to you to talk about legislative updates in 2025.
Okay, sounds great. Thanks, Stuart. So we definitely have a few legislative changes of note in 2025. Just a warning, this is going to be Ontario specific, just in the interest of time. Otherwise, I would take over this entire presentation, and nobody wants that. Let's be real.
I can go put my feet up and you can take over. So.
All right, well, let's talk about some of them. So the first one I want to talk about is a new requirement to provide information to employees. This came into effect on July 1st, 2025 of this year, and it requires that an employer provide an employee with certain information before their first day of work, or if that's not possible, as soon thereafter as is reasonably possible. Now, the information that's to be provided is pretty straightforward. It's the legal name of the employer, as well as any operating or business names, if that's different from the legal name, contact information for the employer, including address, telephone number, and 1 or more contact names, a general description of where it is anticipated that the employee will initially be working, their starting hourly or other wage rate or commission rate, the pay period and payday that's established by the employer, and a general description of the employee's initial anticipated hours of work. Now, this requirement does only apply to employers who employ 25 or more employees as of the employee's first day of work. So if you're a small organization with under 25 employees, you don't need to worry about this. What I would say is that a really easy way to comply with these new requirements is just to make sure all of this information is set out in your employment agreement, which you will of course be providing to an employee and receiving a signed copy back before their first day of work. So best practice, even if you are under 25 employees, probably a good idea to have this information set out in your employment agreements anyway. And regardless of size, employment agreements are essential. As Stuart mentioned, contracts are one of the strongest tools that an employer has to reduce their liability. Okay, now let's talk about washrooms. So there's a new requirement under the Occupational Health and Safety Act for clean washrooms that was not in the Occupational Health and Safety Act before this. I know, I am surprised as well. So again, July 1st, 2025, this new requirement came into effect. A constructor or an employer both have an obligation to assure that any washroom facilities provided for worker use are maintained in a clean and sanitary condition. There are going to be additional record keeping requirements in regards to this obligation that are coming into effect on January 1st of next year. So it's important to ensure that your health and safety policies are updated to reflect the new requirements, in particular, once the record keeping requirements come into effect on January 1st. Next update, the Digital Platform Workers' Rights Act finally came into effect this year. This legislation has been around for several years, but it wasn't in force. It is in force as of July 1st of this year. This legislation provides certain rights and protections to gig workers. So individuals working, for example, for Uber or DoorDash. And these are often individuals who would not otherwise have had protection, or there might be some debate about whether they had protection under the Employment Standards Act, often because they're considered contractors. Now, in terms of some of the protections that are established, I'm not going to go into a lot of detail, but things like a minimum wage has been established for the time that a worker is on assignment. Requiring a platform to have a recurring pay period for workers, prohibitions against unauthorized deductions, requirement to provide certain information about pay and pay periods. It also establishes notice requirements for a worker who is being removed from the platform for more than 24 hours, unless the worker has engaged in some form of willful misconduct, which is defined very similarly to under the Employment Standards Act. Okay, and then I want to talk about 2 new leaves of absence. So we have 2 new leaves of absence under the Employment Standards Act, which were introduced courtesy of the Working for Workers 6th Act, which was passed at the end of last year. The first one of these leaves is already in effect. So it came into effect on June 19th of this year. This is the long-term illness leave. This entitles an employee to up to 27 weeks of unpaid job-protected leave in a 52-week period. The employee must have been employed with the employer for at least 13 weeks to be eligible for the leave, and they must be unable to perform the duties of their position because of a serious medical condition. And this has to be confirmed via a certificate from a qualified health practitioner. Now, this entitlement does reset at the end of the 52-week period. So after that time, the employee becomes entitled to an additional 27 weeks of leave if they obtain another medical certificate, but it can never go beyond 27 in the same 52-week period. Now, the time off is dependent on the certificate. So if the certificate indicates they will be unable to perform their duties for a period of less than 27 weeks, they're only eligible for the leave for that lesser period, the period that's identified by the medical professional.
Let's jump in for a second with a 30-second warning.
Oh, thanks. Oh, God, it goes so fast. While this leave is unpaid, employees may be able to apply for EI sickness benefits, which are also available for up to 27 weeks. So it kind of matches that period. This leave does reflect a substantial change, as previously under the Employment Standards Act, we only had 3 days of unpaid sick leave for employees to deal with a personal medical condition. Now, employers already had a duty to accommodate, as Nadia has talked about a lot already, in regards to an employee's disability under the Human Rights Code. So it's not especially that this idea that you might have to provide somebody time off as a form of accommodation is new, but this is now a job protected leave enshrined under the Employment Standards Act. So you need to be mindful of it and consider it when you're considering accommodation, particularly if a leave of absence is involved there. Now, I'm not going to talk any detail about the last leave because it's not in effect yet, but we do have this placement of a child leave was also introduced. This provides a job protected leave of up to 16 weeks for an employee after the placement or arrival of a child into the employee's custody, care, and control through adoption or surrogacy. Again, we don't know when this leave is coming into effect yet, but we will keep you updated as to that.
Awesome. Thank you. And I know you'll be back as well when we look forward to 2026 and more legislative changes. So
absolutely.
So everyone should stay tuned for that. I am going to take the next topic. Initially, I was only going to moderate, but terminations are everyone's favorite topic, including mine. So I'm going to talk a bit about terminations and what's happened in 2025. It's everyone's favorite topic, also every organization's biggest source of potential liability. So first, I want to talk about dismissals without cause, which is, of course, the vast majority of dismissals that we see. And as we've heard a lot about, there are notice entitlements. It can be extremely expensive. There's a lot of myths out there, and I don't want to digress too far, but if you think that every employee is entitled to 1 week of notice per year of service or 1 month of notice per year of service or any other number, you're wrong, because those are all myths that are not accurate. The law takes into account a number of factors, and it is far more complicated than it needs to be, frankly. But one of the trends that we saw continue in 2025 is that we're seeing the notice periods getting longer and longer and longer. And so even if you think it is a month per year, we see cases where people who only work, for less than a year get 6 months of notice. And I've said for years that short service employees tend to get disproportionately lengthy notice periods. That's particularly true where the employee is in a senior role, if they're close to the traditional retirement age, if they were induced to leave prior employment. That's a huge factor. This is where we see the cases where someone works for 6 months and gets 6 months of notice or something like that. So just because you have someone who's been employed for a short term, less than a year, let's say, don't assume that you can just let them go, give them a couple of weeks, and all is good. The courts also have confirmed that generally speaking, the max is 24 months, but you can go beyond that in unusual circumstances. And we still see cases of 26, 28, 30 months. And the common factor seems to be that it's someone who obviously has been in the job for a long time. They are typically older because of the length of time they've been in the job. It goes without saying, but also they have a skill set that is not easily transferable. So it's going to be even harder for them to find new work. Those are typically the cases that are going beyond 24 months. So that's one side of things. And I also want to talk about my favorite topic, which is terminations for cause. And I'll still say what I often say, contrary to popular belief, you can fire people in Canada. And when I wrote my book, which is called You're Fired, I coined a phrase called just cause, or which is just cause is not a lost cause. I stand by that. We update the book every year. And every year we see cases where courts or arbitrators have agreed that there was just cause for dismissal. But the threshold is high. And if you do it in bad faith, you end up paying a lot more than you would have paid if you just paid severance. And I'll talk briefly about that if I have time. But I want to go through a couple of recent cases, and I'm going to go through them pretty quickly. One involved a Canada Post worker who was essentially confronted because he wasn't delivering flyers, which is clearly a fundamental part of his job. When he was confronted, he essentially said, of course I didn't deliver them, and referred to the system as stupid, among other even more offensive words. The termination was upheld. Notably, the employee had been suspended several times before. So that's one. Another case involving Sobeys. A colleague of the subject worker complained that he'd been making sexual comments to her. When he was confronted, he did not apologize. He was completely unapologetic and made an excuse about the fact that the company sold adult magazines, and somehow this justified his behavior. There was evidence that he had had harassment training. There was also evidence that he had 2 previous warnings on his record. So the labor board found that termination was upheld. In a third case, we have an individual working on a mining site, safety sensitive position. There were very clear rules that when you lock, this is in this case a 450-pound truck, you've got to put wheel locks on. He didn't. The truck rolled downhill. The employee was confronted. He gave various shifting explanations. Ultimately, the court found, or I should say in this case, the arbitrator found that he couldn't be trusted, and the termination was upheld. And in one more involving Fiera Foods, an employee was caught swapping time cards with a colleague. The employee was confronted on 3 occasions, and on every occasion, his story shifted, but he always denied any wrongdoing. And in one case, when they had video footage that they confronted him with, he claimed the video footage was fake. So again, here, termination was upheld because the employee could not be trusted and took no responsibility. So I don't need to go over the rest of the cases. You can see the common thread here. In each of those cases, the employee was confronted. And in each of those cases, the employee was dishonest, unremorseful, refused to take any responsibility for their actions. And that is ultimately the key question. When you're assessing if you have just cause for dismissal, the question is whether the employment relationship has been irreparably harmed. You have to take into account all factors, and one of those factors is most definitely how they respond when they are confronted. And we continue to have clients who push back when we tell them that they need to investigate, and they need to, part of that investigation should be confronting the employee, and they say it's going to be a waste of time. These cases demonstrate that it's not, because in many cases it will make your position much stronger to not only show that the employee engaged in misconduct, but they were unapologetic, unremorseful, and gave you no reason to think that they would behave in a better way in the future. That's essentially just cause for dismissal. So I've talked a little bit about investigations, which is going to be my segue to our next topic. So Jeff is going to be back again to talk some more about investigations and update us on how things have changed in 2025.
Yeah, thanks, Stuart. And what I'm going to discuss is going to sound strikingly similar to what Stuart just discussed, because I was going to talk about Abbas Bailey and Fiera Foods to the largest extent. But so Stuart has thankfully,
I probably should have compared notes on that. But
no, it's quite all right. It's quite all right. We're probably going to run over time anyway, so I won't go into too much detail about this. But yeah, Stuart, as he touched upon, this was an individual who was committing time fraud. He was essentially the material fact of it is that he was signing in for his buddy, and his buddy was signing in for him. And the employer confronted him with evidence of the fact that he had done so, including data from the time sheets that had they both had faked, and actual video footage of this guy signing in for his buddy, and his buddy signing in for him, and the corresponding data. The employer investigated to a great detail and confronted this guy on 3 separate occasions. And as Stuart indicated, he indicated that it was fugazi. It was, you were lying about the information, and to the point that he got up and he actually walked out of all 3 investigation meetings, which is probably my favorite detail of this entire story. Fiera Foods has been in the news a couple of times for the reasons it's interesting to see it for this as well. Yeah, he gave false answers. He was evasive throughout the entire process. the ultimate takeaway from this, from my perspective, is that it is still possible to dismiss an employee. This guy had 13 years of service and he had a fairly good disciplinary record previously. The employer conducted a thorough investigation and was able to substantiate a dismissal for cause and didn't have to pay this guy anything. The takeaway from an employee's perspective, and I'm not sure if you touched on this, Stuart, if you did, I may have missed it, is that it's possible that if this guy had been contrite and had acknowledged his misconduct when he was caught, frankly, red-handed, first off, the employer may have said, well, listen, what you did was wrong, but you're a good employee and we understand you're a family man and we're going to keep you around. And they may have kept him on. Or if they had proceeded to dismiss him after he had been contrite and acknowledged in the face of this overwhelming evidence that he had committed misconduct, they proceed with a dismissal for cause, the court may have said, well, listen, this guy demonstrated contrition. There was maybe some relationship that could have been salvaged here. And irrespective of the fact that you had this overwhelming evidence, you should have brought him back on and used this as a teachable moment. And then they may have found that he may have been entitled to notice after the fact. And as Stuart has instructed me, and I've learned everything I know about cause from Stuart, is that there's no such thing as near cause. So even if the court had said, well, listen, there's overwhelming evidence. And the other thing that came into play here as well is that he asserted he'd been dismissed for trying to start a union and trying to bring health and safety information to the employer's attention. And they could have relied on all the investigation stuff to show that, yeah, we had a basis to dismiss and it wasn't what he's claiming. But essentially, even if they had all this investigation stuff, if the court had found that the guy had been contrite and there was a chance to salvage the relationship, he would have been, it's an all or nothing proposition, right? He would have received notice, even though potentially we had a cause to dismiss, he would have still received notice of the dismissal. And it's not like they would have discounted the notice and, well, we got partially there, so we're going to give him half. The close only counts in horseshoes and hand grenades, ultimately. But
that's a great point. Sorry to jump in, but it's a really great point, and on two fronts. But the first point you made is really great, which is that if he had been contrite, if he had been apologetic, if he'd given the employer reasonable assurances it wouldn't happen again. I find judges, they all use one variation or another of this phrase, which is that, yes, the employee engaged in misconduct, but summary dismissal was not warranted and some lesser form of discipline would have been appropriate. And we can talk in another episode about the fact that you really don't have a whole lot of options when it comes to discipline. But the point is that, depending on the circumstances, not all misconduct warrants dismissal. And I think that's, you made that point. And no, I'll stop interrupting you, let you keep going on that.
And thank you, Stuart. Yeah, and I reiterate, I learned everything I know about this from you. So I mean, it's good to hear it back from the source and know that my information is correct. And the takeaway I have from this ultimately is, conduct a proper investigation. If you're going to rely on an employee's misconduct or employee's behavior for cause, do a proper investigation before you dismiss the employee. If you have concerns about the employee, continuing to do this misconduct while you conduct the investigation, you can potentially put them on a leave of absence, like a paid leave of absence. That's getting into a constructive dismissal argument, but again, you can work through this with your lawyer and conduct the investigation. It's really easier to conduct the investigation prior to acting than to act and then try to backtrace everything and try to figure things out. Because what if you figure out, oh, I was wrong and I shouldn't have fired this guy for cause, and that's going to be incredibly expensive. And we want to avoid expensive conversations whenever we can. And ultimately, don't rush to judgment is the do and don't that I come with. It's just because you think somebody's done something, don't act until you're certain of it.
That's one of the key points of the investigation. And just on that last point you made, I mean, I think it's important if you do have concerns, you suspect misconduct, you're going to investigate, put the employee on an administrative leave, not a suspension, because that suggests discipline, but put them on an administrative leave pending investigation, because ultimately, and this is a common mistake, right? If you are alleging that you had just cause, you're basically telling a court that you could not reasonably be expected to continue employing this person. So it's kind of undermines your argument when you continue to employ that person while you investigate. So don't do it. Put them on the leave. It's paid, which I know a lot of employers don't like, but it's a necessary step if you're going to do this properly and basically try to eliminate your potential liability. So thanks for that great summary of a case that I glossed over pretty quickly.
Yeah, well, you give me more time than you give yourself, so that's perfect.
All right, so we'll keep moving forward with the last topic of our look back at 2025. So Alex is going to be back by popular demand, this time to talk about general damages, because as anybody who's seen claims in the last 20, 25 years will know, almost every statement of claim for wrongful dismissal includes some allegation of bad faith or something like that, and then seeks general damages. So, and that's another thing that's changed a lot over the last couple of decades. And Alex, I'll turn it over to you to talk about how it changed in the last year.
Thank you, Stuart. So Stuart's absolutely correct that we see this claimed a lot in a statement of claim for an award of general damages or punitive damages in addition to the usual damages for wrongful dismissal. But just because it's claimed doesn't mean it's going to be awarded. And generally speaking, these damages are not awarded in most cases and are reserved for exceptional situations. So I'm going to discuss two recent cases from this year that consider these additional damages awards and discuss how the quantum of those awards are determined. So the first case is from the Human Rights Tribunal of Ontario. The case is Tompkins and Peninsula Grill from just a few weeks ago. In that case, the employee was fired explicitly because of attending a medical appointment. And this wasn't just asserted, this was clear from the text messages between the employee and their boss. There did appear to be other reasons for the dismissal as well, but attending the medical appointment certainly was a factor. Now, by putting this in a text message, the employer made this determination very easy for the tribunal to make, and it was clearly a violation of the Human Rights Code. So while the tribunal did make a damages award, it was perhaps not as significant an award as some may think for such a blatant breach of the law. So the tribunal awarded just over $400 for lost wages, which it limited to only 2 weeks of base earnings. And then it also awarded general damages of $15,000. Which the board described as monetary compensation for injury to her dignity, feelings, and self-respect under the Human Rights Code. So $15,000 in general damages is, of course, somewhat significant, but it also emphasizes that the Human Rights Tribunal is not going to award exceptionally high damages, even when there is a blatant breach of the Human Rights Code. The second case I'll discuss is Carroll and Oracle, which is a decision of the Ontario Superior Court of Justice from August of this year. This included an award of punitive damages in addition to wrongful dismissal damages. And there were essentially two reasons for that award. First of all, there was commissions of about $57,000 that were owed to the employee that weren't initially paid. They were ultimately paid 8 months late. The employer, Oracle, claimed that it was missing information that prevented it from paying the commissions on time. But through the discovery process, it came to light that that wasn't true, that all the information was available. So there really was no justification for paying her those owed commissions so late. Secondly, Oracle maintained that the employee was limited to statutory notice only due to a termination clause in the contract. However, the court had already considered the exact same termination clause in another court decision involving Oracle and had already found that that termination clause was unenforceable. So the court said Oracle's position was untenable. And Oracle held that position until very late in the process and then withdrew that position and really had no reasonable explanation for why they maintained that position so late. So the court found that this was conduct that appeared to be an attempt to pressure a financially vulnerable employee rather than a genuine dispute over legal issues. So essentially, there was the failure to pay the commissions that were owed to her for a long period of time, as well as maintaining a known invalid clause. The court found these two things constituted a breach of duty of good faith. The court ultimately awarded punitive damages of $57,740, which was the exact same amount as the amount of commissions that were withheld. And this was in addition to the commissions that were owing, because that was paid, albeit very late. But essentially, the employee received double for those commissions. So the approach essentially was the higher the amounts that were withheld, the higher the punitive damages would have been. So looking at both of these cases, we see two very different approaches to additional damages awards and two very different ranges of what the quantum of these awards can be.
Well, thanks, Alex. And yeah, it's interesting. And on the first point, I actually just recorded a fire away recently on that first case. And it's still shocking to me that the numbers are so low for human rights breaches. And on the second point, $57,000 is substantial, but we've also seen a lot of cases, I guess not in 2025, but in previous years with the number getting higher. So, but you made a really important point at the beginning, only when it's actually proven that there's basis, not when it's just alleged.
And I do find the approach the court took in the second case to be very interesting, to essentially link it to the amounts that were withheld, rather than coming up with a number out of thin air. Really giving the incentive to an employer not to withhold large amounts, because the larger that is withheld, the larger the punitive damages award would be.
Yeah, no, I think it's a great point. And if they're trying to make a business decision and say, well, we could save X even if we're risking Y, the court basically nullified that by saying whatever you think you're saving, you're going to end up losing it. So, all right. So thank you for that. And that concludes our update section, looking back at 2025. So we're going to take a short period of time to look into our crystal ball at what to expect in 2026. Before we do, a brief word from our sponsor, which is Rudner Law, of course. So I just want to jump in and quickly repeat an offer I've made many times in the last few years, which is that we will be happy to review your employment contract templates. As we've talked about a lot, termination clauses that you may have thought are enforceable, that may have been drafted a year or two ago by an employment lawyer, may not be enforceable. And in fact, I will bet that of those of you who send me your contracts, at least 3/4 of them will include termination clauses that are not enforceable. So I'd be happy to take a look at your employment contract template and have a brief chat with you and offer you some feedback. So please take us up on that. You can email me and I'll repeat this later. And of course, it's pretty easy to find any of us online.
At Rudner Law, we want people to treat their employment relationships as legal relationships and make informed decisions rather than assumptions. Keep up to date on Canadian employment law issues by following us on Twitter, Instagram, LinkedIn, and TikTok, liking our Facebook page, subscribing to our YouTube channel, and signing up for our newsletter. Past episodes can be found on YouTube, on our website, and archived on Facebook. And if you like our page or subscribe to our channel, you will receive notifications when the episodes are live. As we always say, none of that replaces legal advice tailored to your specific circumstances. If you think you might need an employment lawyer, you probably do. So please don't hesitate to reach out to us.